What is a refusal hearing? In Indiana, if you're charged with an operating a vehicle while intoxicated charge, and during the course of that investigation, you refuse a chemical test, you're going to be deemed what's called a refusal. Now that's going to lead to an automatic 1-year suspension of your driver's license. Now where the refusal hearing comes in, not as a part where your attorney can actually fight whether or not you actually refuse that and try to alleviate some of the negative effects that it can have on your license. So if you're pulled over and suspected of drinking and driving, the officer is going to look for signs of intoxication. That can be an odor of alcohol on your breath, your speech is slurred, glossy eyes, if there's alcohol beverages in plain view, things of that nature. After that, the officer is probably going to ask you to do what's called standardized field sobriety tests. Now that can be an eye test, which is also known as HGM. It could be a one-legged stand, where the officer will have you stand on one leg and count to a specific number of seconds. And the third can be a walk and turn test, where the officer is going to have you walk in a straight line, turn around, and come back. Now, based on his initial observations, along with those field sobriety tests, the officer can come to the conclusion that he has probable cause to believe that you are operating a vehicle while intoxicated. Now, once an officer has probable cause to believe that you are intoxicated, they're going to ask you to consent to a chemical test. This is called Indiana implied consent. Basically, the officer is going to tell you that he has probable cause to believe that you are intoxicated and therefore is requesting that you submit to a chemical test to confirm or disprove his hunch that you're intoxicated. Now, a chemical test can be a certified breath test where you go to the police station and blow into a machine, or it can be a test at the hospital where a nurse draws your blood and they do the alcohol analysis through the blood rather than in the breath. Now, if you refuse the officer's request to consent to a chemical test, that's going to be called a refusal, and that's what's going to lead to an automatic 1-year license suspension. Now, what is a refusal? Really, anything except an absolute yes is going to be deemed a refusal. So the obvious way that people will say, well, I said no, that's clearly a refusal. But staying silent, asking questions can also be a refusal as well. Basically, unless you tell the officer, yes, I submit to these tests, you're going to be deemed a refusal, and at that point the officer is going to apply for a search warrant to try to obtain your breath or blood. Now, if you think that you've been wrongfully accused of having a refusal, you can ask your attorney to ask the court for a hearing where the state of Indiana will have to bring in that police officer and have him testify as to why he believes that you were a refusal. And then at that point, your attorney can argue against that and argue to the judge why he thinks this was not a refusal. Now, depending on the outcome of that case, the refusal may be dropped, and at that point you can have specialized driving privileges while the case is pending. If you're a refusal suspension, you can keep driving pre-trial on some occasions with an interlock device. This is something that your attorney can file. It's called a motion to have an interlock device in lieu of a suspension. However, that only lasts for pre-trial. If you are convicted or take a plea when that refusal is still in effect, that is when the interlock stops, and any time after that you will not going to be able to drive regardless. So getting rid of a refusal suspension is very important. If you have questions about a refusal suspension or are facing charges for operating a vehicle while intoxicated in Indiana, please give us at the Marc Lopez Law Firm a phone call, 317-632-3642, and always remember, plead the fifth.